Yo, what's up, fellas? It's Friday night. It is Friday night, sirs. What's up with it? What's up, Chris? Waiting for a few people to show up and we'll get down to the business. Can you hear me? Hold on. What's good? What's good? Can you hear me now? Yes, sir. Yes, sir. Yes, sir. Yeah, we're gonna talk about is child support unconstitutional? Yeah, that's what we're gonna talk about. Cause it's a woman on here, and she read this Supreme State Court case in Minnesota, and they declared child support unconstitutional. But I'm gonna tell you something. What's so crazy about this shit is, I got the book with the case here, and I can't find the motherfucking. I'm gonna dig for it real good. I'm gonna search it, then I'm gonna come back. If I can't find it now, I'm gonna come back. I'm gonna do a short video on it and what it says. And she's setting these niggas up, talking about child support is unconstitutional. And she said, put this in your paperwork and has no probable cause. Well, we all know that it's the thing about child support people don't understand. Child support is a service. Child support is a business that our bitch ass baby mamas, aka child mothers, goes and signs up for, right? She goes and signs up for $25 for a service. Okay. It's almost like getting a license. You gotta go sign, fill out that little paperwork, get that license, and pay that little punk ass fee. Right? And a lot of niggas is following a woman, thinking the woman gonna help them get off of child support. And she not even talking about the bitches, she just attacking the child support agency. Right? I'm finna start in 1 minute. And I'm gonna read some remedies. Off from a book. We got 30 seconds. All right, let me go and start. Well, we reserve all our rights, waive none. We're not anti-government sovereign citizen movement. We ain't none of that dumbass shit. We run this child support shit. We ain't giving it back. Okay. What's up, Sean? Peace. Now let me hit y'all with something. Y'all ready for this? The only way child support, and we ain't giving out no legal advice. The only way child support is unconstitutional. If they just say, hey, they put you find out that you on child support, right? They didn't give you no notice. If they don't give you due process by giving you a notice or a hearing, then that's an unconstitutional violation. Okay. They have to give you due process. They have to mail you something in the mail. Like, hey, it's a summons. You got to be personally served with a summons by a process server in your hand, really. And that summons will tell you, hey, you've been sued. You got 30 days to respond. That go your due process right there. And then they'll give you a court date. And they supposed to give you a court date. Now, like with the driver's license, if they send you a notice without no opportunity to be heard, right? That's a procedural due process violation. Okay? That's what that is. For all driver's license and shit, they ain't child support and driver's license don't have nothing to do with each other. If you get a notice in the mail that your license being suspended, and if your ass don't answer it back or point out these key notes that I said, they're gonna suspend that shit. So when they send you the notice, you answer that shit. And you request a fucking hearing. Okay? So let me play y'all something what this lady said. She didn't even read the fucking case either. Hold on. Because this shit is so simple to beat, man. I think her name is Iron Sharpens Counsel. And there was some niggas telling me about her. Like, bro. No. Let me let y'all hear this shit.
For you. Child support was declared unconstitutional by the Supreme Court. Supreme Court decisions are a judge's Achilles heel. It is their death knell. When you find Supreme Court decisions supporting your case,
it's a Minnesota Supreme Court case, okay? Minnesota.
It's a wrap. Okay, let me read it to you. It's delicious. Okay. Child support was declared unconstitutional in a Minnesota Supreme Court ruling for violating the separation of powers required by the Minnesota Constitution in Article 3, Section 1. Further, child support agencies' actions are also unconstitutional due to lack of probable cause. You don't even have to find case law. Just quote everything that I just said. Put that in a notice and send that to the clerk of court.
Yeah, they're gonna like, and so what? They're gonna say, and so fucking what? You know what I mean? Child support is constitutional, fellas. Child support is constitutional because it's a fucking business, because it's voluntary that they provide to these hoes. Right? So that shit is constitutional. It's constitutional. It's a contract. It's a fucking business. You either can pay the shit or you can just say, fuck you, I ain't giving you a motherfucking thing. Because guess what? They want to say it's unconstitutional, but what about the freedom to contract? Did y'all know that's a constitutional right of freedom to contract? Right? You ready for this one? The United States Constitution says no one should be in prison for a debt. Right? So you mean to tell me the state constitution is going to go override the federal constitution? No. No, sir. That ain't how that works. Real talk. So be careful who you get your advice from about child support, right? Child support is a debt collection agency, aka in business. Because if you look at every child support agency in the state, they are registered with the banking club organization, especially here in Texas. Here in Texas, they are registered with the banking club, commerce, right? They're registered. They're here to do business. Real talk. Child support ain't shit. It is 2023 and no one should be on fucking child support. Okay? And if a lot of niggas had common sense, they'll say, well, if the bitch can't take care of the child, want some money from me, that means she don't need my motherfucking children. She's a sorry hoe. Come on, man, let that sink in. Let that shit sink in. Child support ain't got shit with the it ain't got shit to do with the fucking Constitution at all. It's a business. It's just like 7-Eleven. You walk in, you can go in there and buy you something, or you can walk just straight out that motherfucker. See, simplicity kills a dumb motherfucker. I'm simple. I am not difficult. Somebody who is simple like me kills a dumb motherfucker. Want to learn all this legal this and legal that, and you can't go in there and be a man like, nigga, fuck you. I ain't paying you shit. That's what I did. I put in a little bullshit paperwork. I put that shit on there. Obligor means to make a promise to pay a motherfucker. That's the real definition of an obligor. An obligee is a motherfucker that gives out credit. Did the bitch loan you something? Did the agency loan you something? Or did your ass go in there and sign up as an obligor saying you promise to pay for her one night stand? So guess what? The answer to this video: child support ain't got shit to do with the Constitution. Not a goddamn thing. Now, if they big and bold, they want to try to run over you and shit, right? Then that's you letting these people run over you. Don't let nobody run over you. Don't let nobody force you into a motherfucking contract. Don't let nobody tell you about your fucking children, nigga. What the fuck wrong with y'all? See, they knock your natural rights out and try to get you to play the legal game with their bitch asses. They try to knock out your common sense. See, child support is here to play on your emotions and knock out your common sense. Trying to knock out your manhood. Trying to distract you from saying no. There ain't no bitch on this planet, no judge, no motherfucker who gonna tell me what the fuck I'm gonna do with my children. Because number one, they weren't in the motherfucking bedroom when I was getting my dick sucked, getting my dick wet. When they was riding this cock, licking this balls, right? Am I saying something? They weren't in the bedroom with you when you was getting your dick sucked, fucking her from behind when you made your fucking children. They weren't in there. You need to get back to where it was from the beginning. Start from the beginning. I met the bitch. We liked each other. We fucked. I busted nut in her. Wasn't nobody in the bedroom. You should stay that way and keep it that way. That's where that shit started, in the bedroom, and should stay in the bedroom. You made your children in the fucking bedroom. You didn't make your children in the courtroom, nigga. Y'all need to start being disrespectful to these motherfuckers because they already being disrespectful to you, sending they fucking paperwork that ain't yours. You ain't the author of that paperwork in the mail. You ain't the pussy ass, faggot ass court clerk. You ain't the motherfucker talking about he the goddamn judge when you know he ain't nothing but a fucking your neighbor or somebody or a punk ass flunky lawyer or somebody. It doesn't take a rocket scientist to figure this shit out. I'm finna read y'all some shit right now. Some goddamn remedies. God damn it. Hold on a second. Nah, ain't they fucking business what the fuck you do. Don't let another grown motherfucker tell you what the fuck to do. We grown, fellas. You don't let no pussy ass police tell you what to do. And I don't like them punk ass niggas interfering with domestic relations. Shit. Okay, I'm gonna read y'all something. I'm gonna read y'all something. This is a tort claim. This is called right to be brought promptly in front of a magistrate. So if you go to jail, they have you sitting, they book you, process you, and they have you sitting, and they don't take you straight to a fucking magistrate. That's a tort claim. Let me read it to you. The Court of Appeals for the Fourth Circuit has noted that the period of post-arrest detention prior to bringing an arrestee before a magistrate may only be long enough to take the administrative steps incident to arrest. Fisher versus Washington Metropolitan Area Transit Authority. Did y'all hear that? Y'all need to write that shit down. I'll replay this motherfucker. A 42-hour detention without being brought before a magistrate for a judicial determination of probable cause is violative of the 14th Amendment and is actionable in a 1983 claim. Longley Gould versus Miggy, 1984 Illinois case. It's an Illinois case. A probable cause determination before a magistrate may be delayed because the arrestees were intoxicated when arrested. That's in Canokia versus Honolulu. All right. The Supreme Court has now defined how promptly an arrestee must be brought before a magistrate to satisfy a Fourth Amendment in the context of a 1983 class action. The court ruled that judicial determinations of the probable cause within 48 hours of arrest will, as a general matter, comply with the promptness required of the Constitution. County versus Riverside versus McLaughlin, 1991. What's up? Let me read some more shit. Hold on. Here go a good one. Right to an impartial tribunal, which impartial means fair, right? The Court of Appeals of the Eighth Circuit has held that although a black defendant is not entitled to a jury containing members of his race, a state's purposeful or deliberate denial to Negroes on account of race of participation as jurors in the administration of equal justice violates the Equal Protection Clause. White versus Bloom. And that case in 1980 in Missouri. Hey man, I got some shit over here, dude. Y'all ready for this one? Freedom from assault and bodily injury. In order to hold a police officer liable under 1983, it is not necessary to show that the officer actively participated in the beating. It is enough if the officer failed to intervene in a beating being administered by another officer in the presence in his presence. Man, write this down. I'm gonna sing it. Write this down. I'm gonna read it again. Freedom from assault and bodily injury. In order to hold police officers liable under 1983, it is not necessary to show that the officer actively participated in the beating. It is enough if the officer failed to intervene in a beating being administered by another officer in his presence. Bruner versus Dunway, 1982. That's a California/Tennessee. Y'all hear that? A sexual assault by an on-duty policeman constitutes a violation of the constitutional rights actionable under 1983. Widgeworth versus Harris. That's in Wisconsin. That's a Wisconsin case. Okay. Check this out. The unwarranted shooting of an incident motorist by police officers gives rise to 1983 liability. Rodriguez versus Cartagena. Let me keep going. Freedom from false imprisonment. Let me see, do I have that one? 142. Okay, y'all gonna like this. Freedom from false imprisonment. In a case where a man was found slumped over the steering wheel of a car due to a massive stroke, but was arrested without a warrant and put in the drunk tank for 19 and a half hours, it was determined that such confinement could be the basis for a claim. Reeves versus Jackson, 1975. That's a Mississippi. That's a Mississippi case. When a person is arrested pursuant to a facially valid warrant and makes no assertion that the arrest was constitutionally deficient, you hear that? If you don't claim that that shit was constitutionally deficient, let me read it. A 1983 claim of false imprisonment cannot be supported by the fact that he was detained in jail despite his protest of mistaken identity. So long as the warrant confirms the constitutional standards, a person's innocence of the charge contained in the warrant, while relevant to a tort claim, a false imprisonment is irrelevant to a claim of deprivation of liberty without due process of law. Did you hear that? Let me give you the case for that. Baker versus McCollum. That's a Supreme Court case. 1979, 443 U.S., United States, on remand. And it's a Texas case too. Mark versus Furay. Illinois case as well, 1985. Okay, hold on. Let me see what else we got. Check this out. A person placed in a facility for mental evaluation without probable cause may seek redress under 1983 for a deprivation of liberty without due process. Rex versus Temple, Colorado case. Ooh, y'all about to love this one right here. Check this out, nigga. A sheriff may be liable under 1983 for the acts of false imprisonment of his subordinates if the sheriff did not adopt reasonable internal procedures to ensure that only those persons are incarcerated from whom the sheriff or his deputies has a good faith belief that he possesses valid legal authority to imprison. Dohit versus Jones, 1981. That's a Texas case. See also Williams versus Hurd, Texas case. Boy, I'm giving y'all some good shit. Now check this one out. Although a prisoner may not bring a 1983 action to attack the validity of his conviction, such as an action may lie to vindicate his right to be free from false imprisonment should his conviction later be overturned. That's when you fight a conviction instead of taking an expungement. So, fellas, don't take no expungement. If you take an expungement, that means your ass was guilty of the crime. But if you fight the wrongful conviction, you go back and go get that motherfucking ass. Guess what? You get that shit overturned, and you don't have to have no expungement on your record. A bitch ass lawyer ain't gonna tell you what I'm telling you. I'm gonna keep reading, goddammit. Then we having us a good old session. Fuck these hoe ass bitch ass lawyers out here. Hold on. Check this shit out. Y'all ready for this one? Where a deputy constable altered material information on a arrest leading to the arrest and false imprisonment of the plaintiff, recovery under 1983 could be had notwithstanding that the plaintiff was arrested pursuant to a facially valid warrant. Brown versus Bayer, 1989, Texas. The Fifth Circuit recognizes a causative of action under 1983 for a false imprisonment. Sanders versus English. That's a Louisiana case. What's up, fellas? Hey, man, this book is straight from the law library. Okay? What I'm reading, y'all, this shit comes out the law library in Austin, Texas, downtown, nigga. With a Supreme Court, Texas Supreme Court is inside. See, niggas can win a case. The only thing that stops a lot of dudes from winning the case is them learning how to tell what the case is about, stating their claim, you know what I mean, and back it up with law. Long as you tell the truth in the court case, what happened to you, you gonna win. But if you leave stuff out, you didn't say this and you say that, they're gonna attack your ass on that stuff. They're gonna attack that. They're gonna attack the deficiencies of your claim. They're gonna get you on technicalities, right? Because nobody know your case no better than you. You can only tell me what happened to you. But I don't know the whole thing because I wasn't there. So I have to do my best to wrap this shit all in a nutshell. You know what I mean? We here to help you. We not here to harm you. Now, we done had niggas that flipped on us for helping their naughty head asses. So you can't flip on us when we're here to help you. We're not the ones that's putting you in jail. We're not the ones that's garnishing your check. We're not the one that's rocking with your baby mama, taking the money, fucking her from behind, and taking your money. Say, yeah, nigga, we getting this money from this bitch ass. Yeah, thank you, nigga, for paying this child support. I'm beating your bitch pussy up. That ain't us, okay? That is not us. We're here to advocate for you. We're here to help fight for you. We're your advocates, okay? We're just going to get that shit straight. All right? Freedom, you are going to love this shit right here, fellas. Check this shit out. I don't know if you got your pen, get you a blunt, get you a motherfucking drink, you know what I mean? And enjoy this shit. I don't know if you drink wine. Enjoy what I'm finna read you. Freedom from malicious prosecution and malicious abuse of process, unlawful attachment. Man, oh man, oh man, oh man, oh man. You gonna love this. The Second Circuit has held that to support a defense of selective or discriminatory prosecution, a defendant bears the burden of establishing that, number one, the person compared with others similarly situated was selectively treated, and number two, that such selective treatment was based on impermissible considerations such as race, religion, intent, inhabited, or punish the exercise of constitutional rights or malicious or bad faith intent to injure the person. Nigga, don't that sound like child support, what I just read you? Let me give you the case law. Claire versus Saunders, 1980, California, Vermont, and it's part of the, hey, check this out. It's in Connecticut, too. It's a Connecticut case, too. Look at here, Brother Sean. Connecticut, too. Child support is malicious prosecution, malicious abuse, and process unlawful attachment. This is child support right here. This is child support, what I just read, y'all. All they proceedings are malicious, nigga. They fabricate the fucking record, nigga. They don't want you to see what the bitch affidavit talking about she ain't got no money, but you can catch her ass on Facebook talking about they going out. They finna go overseas. They buying hair. Selling food stamps. Right? Y'all need to get y'all ass on Facebook, follow your baby mamas, and screenshot all the bullshit that she lying to this motherfucking place we call child support circus, aka court, and throw that shit in their motherfucking face. Take a picture of that shit, what she doing, mail that shit to the courthouse, and say you a motherfucking liar. You ain't getting no goddamn money. Fuck you. And fuck her too. Let me keep going, goddammit. This is some good shit tonight. In a 1983 action alleges deprivation of liberty without due process through unlawful arrest, false imprisonment, and malicious prosecution, defendants allegedly malicious motives are irrelevant where they have probable cause to believe in the plaintiff's guilt. Right? That's why I say you can't be lying on what's going on. Exactly. Exactly. If she does it to you, it's only fair you do it to her. Ain't that right, Marshman the Third? God damn it. The Seventh Circuit states that malicious prosecution oh Lord. The Seventh Circuit states that malicious prosecution perhaps is actionable under 1983. Terharsky versus County of Lake, California, Illinois case. You ready for this? The Second Circuit has noted that where a 1983 claim is essential for deprivation of civil rights through malicious prosecution, federal courts will generally look to common law requirements to support a claim of malicious prosecution in judging the merits of the 1983 action. Let me read it again, and I'm going to give you the case. The Second Circuit has noted that where a 1983 claim is essentially for deprivation of civil rights through malicious prosecution, federal courts will generally look to common law requirements to support a claim of malicious prosecution in judging the merits of the 1983 action. San Filippo versus United States Trust Company. Did y'all hear that? Did you hear that? And people don't know the 1983 is the tort claim. The 1983 is a tort claim. Some courts have ruled that persons are not protected from now listen to this. Some courts have ruled that persons are not, some courts, not all courts, protected from malicious claims through 1983 actions, but the better view is to the contrary. Citing Federal Civil Rights Acts. See also Dunn versus Tennessee. That's a good one. The Sixth Circuit has declined to hold that the Eighth Amendment prohibition against cruel and unusual punishment creates a federally protected right against malicious prosecution. Bacon versus Petra. This is some good shit, fella. God damn. Ooh, here go one right here, fellas. You ready for this one? These punk ass lawyers. The filing of criminal charges without probable cause for reasons of personal animosity is actionable under 1983. Write this shit down. The filing of criminal charges without probable cause for reasons of personal animosity is actionable under 1983. Similarly, filing of such charges to penalize the actions of one's First Amendment right is cognizable under 1983. Luch versus Parksburg, 1984. Pennsylvania. Nigga, what's up, nigga? I'm going to save some more for later. I got a whole book off the law library, right? You can get child support for a tort, man. You can make a tort claim. And we got another remedy too, but motherfuckers they're gonna have to donate for that one. Okay. Real talk. So child support is constitutional, especially if you sign for it, right? And the only way it's unconstitutional if they threaten you to sign by violating your motherfucking constitutional rights. Right? This is good, fellas. Go check these cases out. Right? Go check them out. Do a little homework. You know what I mean? Do your homework before you go, if you want to get somebody's services. Go to the law library, get your read on. Right? Me and Kish, the only two brothers on YouTube who beat two bitches in child support court. What's up, Felipe? 2-bar. Felipe in the house. Felipe and Sean, the main two motherfuckers that told these motherfuckers, man, fuck you, fuck off. I don't owe you shit. I ain't giving you nothing. That's that bitch case. And they fucking case, it ain't even no case no more. They just said, no, they told Felipe we don't want to do business. And told Sean, like, man, one dude jumped in Sean's face and Sean checked this motherfucker and he made his ass go back to his desk and the women got horny and, wanted to give him some pussy after he told them it ain't his case. I'm gonna open up the link. They violate your due process. Yes, sir. Yes, sir. It's all about due process, fellas. Due process. Due process. I got a driver's license case right now for Illinois that if they suspend your license without giving you a hearing, they'll compensate you with some money, my nigga. I got that case law right now. I'm going to embarrass a dude in Illinois. I'm going to embarrass him. If his homeboy want to talk some shit, I'm going to embarrass these idiots, right? And I'm going to show you how retarded they are, right? For flipping on me like a bitch. Like they on their period or something. Like I did something to them. Like I put them in this situation, right? Fellas, I didn't call child support on nobody. I didn't put nobody on child support. I don't like these motherfuckers. All right. I think these niggas should get the ass whooping when they get off of work. I think they should get beat up like the fakes. What's that? Tekashi 6ix9ine. I think every child support worker should be beat up like Tekashi 6ix9ine. I'm serious to the lawyers and to the pussy ass niggas who call themselves judges. They need to be pulled out and beat the fuck out of, and they gonna learn. Let's make ass whoopings great again. in America, fellas. Let's make getting the ass whooping great again in America. Let's put the guns down. We don't need no gun. We don't need no gun. They talking about want to take people guns. Well, everybody give up their guns. Yeah, right. You know everybody gonna do that. That's how you know people stupid. Right? Fellas, you have the right for somebody not to put their hands on you. The only time somebody, if you agree and if you making the deal with somebody on a handshake, that's the only time y'all supposed to be doing something. And guess what? Handshakes ain't worth a damn no more. Let's make ass whoopings great again in America, fellas. Tekashi 6ix9ine. Let's make ass whoopings great again. Because I'm going to tell you something. Motherfuckers going to run out of money on personal security. I don't have personal security because I ain't out here doing people dirty. Okay? I had a bounty hunter call the police on me, nigga. Me. I had a bounty hunter call the police on me, nigga. A bounty hunter. And I got another question, fellas. You ready for this question? It's been itching my ass for so long. You ready for this? On the paying taxes game. Do hitman pay taxes? Huh? Do hired hitman pay taxes? Because he's hired. He's employed to do some shit. Do his ass pay taxes? Well, bro, I said that's a good question now. So why the fuck you pay? Why the fuck we pay taxes? Am I saying something tonight? Let me read another remedy for y'all. Hold on, man. Let me give y'all one more before I run. Let me give you another remedy before I run. Hold on. Woo! This for my boy Felipe. You ready, Felipe? As stated in text, extracting an involuntary confession is actionable under 1983, and this is so whether the coercion is a psychological or physical. Rex versus Teeples. It's a California and Colorado case, my nigga. You hear me? As stated in text, extracting an involuntary confession is actionable under 1983, and this is so whether the coercion is psychological or physical. If they get in your head and tell you, hey, nah, man, you know, like these lawyers, you know you was wrong. You just go ahead and go say that you fucked up. Say you hit the bitch over the head, right? You meant it. Just say you meant it and you pleading guilty. Nobody can't tell you do that shit, nigga. That's a tort claim, nigga. We live in Austin, Texas, god damn it. I'm reading y'all some shit. But hey, man, y'all have a good night. We're going to talk about hoes next Sunday night. We're going to talk about she a hoe, but she can't help it. I'm going to have my brother Sean come up on here, and we're going to go hard on y'all's baby mamas and mine too. We're going to go hard. We're going to make fun of these dumbass hoes, okay? Because they took it too far. They took it from the bedroom to the courtroom. It might be called from the bedroom to the courtroom. Might be called that Sunday night, nigga. Y'all have a good day. Y'all have a good night. Peace.